Hi guys, how are you? I hope you are doing great out there. Myself, CM MOHIT MAKHIJA, a practicing chartered accountant, and today, once again, I welcome you to my YouTube channel, E-SARALARTH. Here at E-SARALARTH, we ensure that everything is made simpler and meaningful in whatever we do, only for you. So, today I want to share some insights with you on the outcomes of latest 49th GST Council meeting held on 18th of February 2023. So, guys, what are we waiting for? Let's get going straight up. So, let's now discuss outcomes and highlights of 49th GST Council meeting dated 18th of February 2023. So, friends, first update is on GST compensation cess. Just as a background, we all know that GST compensation cess is a cess that was supposed to be collected on supply of some select goods and or services or both, like cars, specified motor vehicles, cigarettes, tobacco, aerated waters, etc., till 1st of July 2022. Accordingly, compensation cess regime was supposed to be ended by June 2022. The government, however, has extended the time for levy of GST compensation cess by nearly 4 years and thus has extended this till March 2026. This is because government needs to repay loans taken in last two fiscal years to make up for the shortfall in cess collection. We all know the after effects of COVID, right? So obviously. Okay, next. So just to extend this background, just we discussed, now in this latest GST Council meeting, as an update, it has been concluded. Obviously, it's a press release for now. Notifications are yet to be rolled out. So all pending GST compensation cess of rupees 16,982 crores for the month of June 2022 to be clear to all the states. That is obviously when the compensation cess regime ended. So, but again, since currently there is no amount in this fund, Government of India has decided to clear this balance from its own sources for now. The same obviously is supposed to be recouped from future cess collections. In addition, all admissible final GST compensation cess to be cleared to those states who have provided the revenue figures as certified by the Accountant General of states amounting to rupees 16,524 crores. Okay, so the another update that has just come out in this last meeting of GST Council members is on GST Appellate Tribunal. After years of delay, just as a background, after years of delay, the center was supposed to set up, the GST Appellate Tribunals across this country by around December 2023 with the principal bench supposed to be established in New Delhi to quickly resolve the disputes relating to the key indirect tax and further improve ease of doing business and boost tax collections. But somehow, even 5 years after the GST rollout, the country is still awaiting an appellate body to resolve the tax disputes, much to the hardships of the small and medium taxpayers and to a certain extent, a lot of litigation backlog in the high courts and Supreme Courts. So, uh, based on this long-standing pending need, which is long felt for this resolution of these long-standing disputes, there is another update now on GST Appellate Tribunal. GST Council has adopted the report of group of ministers with certain modifications. Obviously, the group of ministers, whatever report they would have submitted to the council. Council obviously would do certain modifications what as are required, reasonable and feasible, to ensure the practical implication of the overall scheme. The final draft amendments to the GST laws shall be circulated to the members for their comments. The chairperson has been authorized to finalize the same. So, another update in this as an outcome of this GST Council meeting is on capacity based taxation. and a special composition scheme in certain sectors on GST. Again, just to make it more meaningful, let's slightly go in a brief background on this. Prior to GST, there was old excise regime wherein several such products were taxed on maximum machinery capacity installed rather than actual production and sales. But after GST was rolled out in 2017, some states demanded reverting to capacity based installation for the tax evasion prone sector. So, as we all understand, the sectors which we are talking about relates to tobacco, cigarettes, and all on which this capacity-based taxation regime was supposed to be applicable. Now, in May 2021, GST Council had set up a group of ministers committee led by Odisha Finance Minister Niranjan Pujari to examine the feasibility of levying GST on products such as pan masala, gutka, obviously all in the category of tobacco products, on the basis of installed capacity rather than the actual production. This was in the view of large scale tax evasion detected by underreporting of output by the units. But again, considering the practical cost beneficial analysis and the implementational and administrative aspects, this basis of installed capacity was not found feasible. Reason, obviously, because of the difficulties in administration of the input tax credit mechanism, which is otherwise applicable in the normal tax regime, and more importantly, the practical implementation and the effect on the market of this policy was that big players gain in this process of installed capacity taxation regime, wherein they were quick and comfortable to enhance their capacity and to just average out their tax incidence, whereas small players got out of the business as they could not invest in new technology and machines. So, to keep in mind the interest of overall players and business entities, it was not found feasible to consider the basis of installed capacity as a tax evasion prone sector remedy. But somehow, obviously, since it is uh, being faced as a challenge that there is a tax evasion in this sector due to different aspects. So obviously they would be wanting to overcome these challenges through efficiency, better disclosures, or maybe enhanced disclosures and administrative measures. Just to give an insight on this, currently the uh, the rates of compensation cess. Sorry, just let me just go to the slide. Currently, the assorted tobacco items attract highest GST rate of 28%, and also the compensation cess on top of that. The rate of compensation cess on tobacco products range from 135% approx to around 290%, which is exorbitantly high. So, in order to plug revenue leakages, as we just discussed, and improve the revenue collection, the council now has approved, inter alia, other measures in respect of commodities like pan masala, gutka, chewing tobacco. Capacity-based levy is not to be prescribed. This has been concluded. Another thing which is supposed to replace the more harsher step which could have otherwise been taken is that the compliance and tracking measures to be taken to plug leakages or evasions, that needs to be that would be made more sort of stringent, obviously, which would mean for sure enhanced disclosures in this sector. And then exports of such commodities to be allowed only against letter of undertaking with consequential refund of accumulated input tax credit. So there are certain conditions they want to imply. There are certain enhanced, compliances and tracking measures and disclosures which they want to bring in to check the tax evasion, but they do not go or want to go straight away rigid and harsh by the way of capacity based levy, which would for sure affect the small taxpayers and small business owners. So compensation, another update is that compensation cess levied on such commodities to be changed from ad valorem to specific tax collection. Uh, So moving on from compensation cess and capacity based taxation. So next update is in regards to reduction in GST rates. There are two revisions, small revisions, but obviously they were much. They should have been done much earlier. As we can see, jaggery products in form of RAB, the existing rate is 18%, which is exorbitantly high considering the applications of this, agricultural and rural based and basic daily need product. So the GST rate existingly is 18%. This is supposed to be now reduced to 5% if sold pre-packaged and labeled. Otherwise, it will be sold at nil GST rate. Another update is on pencil sharpener from 18% to 12% reduction in GST rate. Okay, coming to the some other changes. Notification number 104 oblique 94 of customs dated 16th of March 1994 amended so that no IGST will be leviable if a device like tag or tracking device or data logger is already affixed on the container. So how the IGST was being charged earlier, to understand the tax implications, understand the the detailing of those tax treatments. If someone wants to go into those details, we will not be able to cover those here. So they can be referred into these stated notification number 104 oblique 94 of customs dated 16th of March 1994. Okay, next update is on serial number 41A of notification number 1 of 2017 in relation to compensation cess rate, so that the exemption benefit covers both coal rejects. So there is an exemption benefit enumerated in serial number 41A of notification number 1 of 2017, but now it has been stated more clearly through this amendment here that coal rejects supplied to or by a coal washery on which compensation cess has been paid and no input tax credit has been availed. Only in such case compensation cess of exemption will be available. Okay. Another update is on trade facilitation measures to make facilitate and mitigate undue hardships and make compliances slightly easier, and to give some opportunity to those who somehow missed out the buck somewhere in the midst earlier. So, Section 30 of CGST Act 2017 and Rule 23 of CGST Rules 2017, extension of time limit for application of for revocation of cancellation of registration. So now the time limit for making the application earlier was 30 days. If a taxpayer's GST registration has been cancelled, so there was a time limit earlier for 30 days, to in which that particular agreed person could have made an application for revocation of his GST registration cancellation. That time limit is now supposed to be increased from 30 days to 90 days. Where registered person fails to apply for such revocation, condonation may also further be approved by commissioner or authorized officer within 180 days. So this is a welcome measure for those who are suffering, who are struggling in this regard. We also have some clients in this regard who have somehow missed out to avail the benefit of revocation provisions, but now hopefully all such cases may further be getting better off, and the taxpayers may further get opportunity to correct their omissions. Another update is again a welcome update. One-time amnesty scheme for past cases. Amendment of to Section 62 of CGST Act has been proposed, where registration has been cancelled on account of non-filing of returns, and such application for revocation could not be filed in 30 days. Again, same many cases we come across this in daily routine practice, that there are many small taxpayers due to some reasons, some at times some personal reasons, or at times some business hardships, or due to lack of awareness, they are not able to file timely returns, and due to existing provisions in the GST law, the registration are cancelled suo motu. Also, in such cases, The one-time amnesty scheme has been proposed. Council has recommended to allow such persons to file such application for revocation by cancellation by a specified time period. Okay. Another update is an one-time amnesty scheme for past cases, also where best judgment assessment order has been issued. Return is filed within 30 days of service of such notice. Such best judgment assessment order is deemed to be withdrawn under subsection 1 of section 62. The council has recommended to amend section 62 and extend the period of 30 days to 60 days, extendable by another 60 days subject to certain conditions. Also for withdrawal of best judgment assessment orders in case pending appeals in relation to such cases. So again, what it implies is that in case there are some best judgment assessment orders or suo motu orders that have been passed, but returns are being filed within 30 days of such notice, such best judgment assessment order is deemed to be withdrawn, obviously pertaining relating recent to this date of council meeting and the press release. In case the return is filed within 30 days of the best judgment assessment, which would have been recently passed, in such cases such notices or such assessment orders for cancellations would be deemed to be quashed. The council recommended to amend section 62 and extend the period of 30 days to 60 days. So extendable by another 60 days. Okay. So uh, just to further simplify, it's a routine process wherein if a particular return is not filed, a best judgment assessment order is generally passed by the GSTN portal. Uh, but if the return is filed within 30 days, in such case, that best judgment assessment order on itself is deemed to be withdrawn under subsection 1 of section 62. But now to further ease up the process, in case the delay was, let's say, 32 days or 35 days or even 40 days, in such cases, that simplified withdrawal of best judgment assessment order was not being made possible earlier due to the earlier provision, whereas now this has been made easier. And this 30 days period is proposed to be extended to 60 days now, and even extendable by another 60 days subject to certain conditions. So what they're trying to do is they're trying to ease out, they're trying to ease up the process, and just not to give unnecessarily hardship to the taxpayers, and unnecessarily sort of authoritative yardstick to the authorities to just uh, sort of harass or exploit, or maybe bring not able even if they want to cooperate, how would they cooperate if the law doesn't provide? So just to be fair to everyone, these amendments were long due, and it's very nice to understand, and it's very apprehendable that the council members have understood the need for this, and they have proposed, and the same has been approved also. Okay, lastly, some other changes also. The benefit of exemption is proposed to be extended, currently available to educational institutions and central or state educational boards for conduct of entrance examinations, to any authority, board, or body set up by central government or state government, including National Testing Agency, for conduct of entrance examination for admission to educational institutions. So the extension of these exemption benefits are being also passed on for conduct of entrance examinations to any authority or board or a body set up by central government or state government, including the National Testing Agency. So again, they're wanting to just promote the infrastructural aspects from the taxation regime, making things easier for education, and sort of processes for educational entities. Therefore, to extend also the dispensation available to central government or state government or parliament and state legislatures with regards payments of GST under reverse charge mechanism to the courts and tribunals also. So in regards to tax in regards to tax. Okay, just to reiterate, uh, as a extension of dispensation available currently only to central government or state government, parliament or state legislatures with regards to payment of GST under reverse charge mechanism to also now courts and tribunals. So what it means is that currently the dispensation is available only to central government or state government or parliament and state legislatures in case, let's say, they provide some taxable services like renting of any premises to any registered person, or for that matter here as here any telecommunication company or any other registered person. So that registered person is supposed to sort of pay GST under reverse charge mechanism in such cases, in case such premises is being rented by the government entity, or sort of government directly for that matter. Now this dispensation has been concluded to be made available to courts and tribunals also, in respect of taxable services provided by them, such as renting of premises to any telecommunication companies or any other installation of any infrastructure on their premises. So I think that's it for now. It's been exciting sharing some great information with you. Thanks for watching, and please request you to subscribe the channel, like and share, for keep receiving the constant information and insightful help in case the video was found relevant to your interests. Thanks for watching and stay tuned. We will want to be stay connected for a lot more to come.